Mr. Sheppard, you have the floor.
Ladies and gentlemen, good afternoon. Thank you very much for that very warm introduction. And thank you in particular to Professor Kalavros and the organisers of this conference for inviting me here. And it's an absolute privilege and honour to come back to Athens and to be able to speak to you now. And the topic I've been given, as you've just heard, is the Res Judicata effect of arbitral awards in subsequent arbitral proceedings. I will first address what we understand by Res Judicata. I will then consider how questions of Res Judicata might arise in subsequent arbitral proceedings, and then I will consider some of the issues that arise when seeking to apply the principles of Res Judicata. But I must first apologise that my perspective is that of the common law lawyer. I've had the benefit of discussing some of these issues with very distinguished civil law lawyers in a committee of the International Law Association. But I would never pretend to be as well informed on the civil law, and in particular Greek law, as my fellow panelists and you, the members of the audience. I must further apologise that I'm not going to have a quiz about Res Judicata for you now. And likewise, I hope that you will not see my presentation as a car crash. So let me start with what we understand by Res Judicata and reminding ourselves of that concept. And I'm sure this is something that is very familiar, but it's a good starting point to find our common ground. Of course, the term Res Judicata refers to the general doctrine that an earlier and final adjudication by a court or arbitration tribunal is conclusive in subsequent proceedings, involving 1, the same matter or relief, 2, the same legal grounds, and 3, the same parties. And this is referred to as the triple identity criteria. The Res Judicata doctrine has existed for many centuries and in different cultures. It's amongst the principles of the Roman jurists such as Justinian, and it has also been recognized by ancient Hindu texts. It is also recognized in international law as a clear example of a general principle of law. Res Judicata is said to have 2 effects on the parties to the judgment or arbitral award. First, a positive effect, namely that a judgment or award is final and binding between them, subject to any available appeal or challenge. And secondly, a negative effect, namely that the subject matter of the judgment or award cannot be re-litigated a second time. The positive effect is largely uncontroversial, that it's final and binding. It's the negative effect, matters cannot be re-litigated, that gives rise to various questions. The rationale for the Res Judicata doctrine finds itself in 2 maxims. It is in the public interest that there should be an end to litigation, and no one should be proceeded against twice for the same cause. It is said that the former is a matter of public policy and that the latter is a matter of private justice. In the common law, Res Judicata is argued as a plea of cause of action estoppel or issue estoppel, rather than as a distinct principle or rule of law called Res Judicata. And it is generally accepted that the res judicata principle applies in the context of international arbitration, such that a final award has res judicata effect, both positive and negative. And indeed, confirming the positive effect, many procedural rules and arbitration legislation expressly state that the award shall be final and binding on the parties. The ICC rule, Article 35(6) as an example, Universal Rules 32(2), the French Civil Procedure Code, Article 1476, the German Code of Civil Procedure 1055, the Universal Model Law, Article 35(1), and of course, the New York Convention at Articles 3 and 4. However, it is not quite as simple as that, which is why we are having a whole session on it this afternoon. So, how might res judicata questions arise in subsequent arbitration proceedings? I'd like to posit three, where first there's a partial and subsequent award or subsequent proceedings by the same tribunal, secondly where an arbitrator or tribunal is replaced, and thirdly in subsequent but separate arbitration proceedings. So taking those in turn. The first situation is where there has been bifurcation of certain issues, and the tribunal issues a partial award. The proceedings continue, it's not thrown out for lack of jurisdiction, the proceedings continue, and in that later phase, new evidence is presented that questions the correctness of the prior partial award. What happens? Now, of course, this is one of the dangers of bifurcation, and there's no doubt why many tribunals tend to join jurisdiction with the merits so that they see more of the picture. Of course, it can also arise if there's bifurcation of liability and damages. Now, in that situation, it appears to me that it is uncontroversial that the prior award has res judicata effect and its findings are final and binding on that same tribunal. In this context, we should remind ourselves of one further phrase, functus officio. After issuing an award, the arbitrator's mandate is finished. Accordingly, the same tribunal has lost its authority to consider and decide the same issues and to reopen findings in the prior partial award that are res judicata. I will consider a little later what we mean by findings, so I'll just come back to that. But as a general proposition, the first or earlier partial awards are final and binding and cannot be reopened. Let me turn to a second situation, and that is where an arbitrator or the whole tribunal has been replaced. Should the new tribunal be bound by previous decisions of the old tribunal? What, and for example, if the previous arbitrator had been replaced because of apparent impartiality? I know of a case where a sole arbitrator resigned because of complaints of apparent bias. He resigned himself. It didn't go through to a successful challenge court, he resigned. The respondents then asked the new tribunal to revisit his previous award on jurisdiction. Why is this different from the first scenario, where I've said that a partial award is final and binding? It is because of this in the English situation. The English Arbitration Act provides at section 27(4) that the tribunal, when reconstituted, shall determine whether and if so, to what extent the previous proceedings should stand. So that was the issue. Could the new tribunal decide whether the previous proceedings should stand or not? Well, in that case, the tribunal concluded that such power could not extend to revisiting a prior award, because only a court can set aside an award and unless and until that happens, the prior award by the previous arbitrator is res judicata. Then let me move on to the third situation, which is where a new arbitration is started. And of course, the straightforward answer is that any prior award is res judicata. But what if the new arbitration raises slightly different issues, but arising out of the same factual foundation? Or it is against a different party? A very typical one is a contractor in the first arbitration is in dispute with the employer, but then subsequently wants to start an arbitration against a subcontractor. What if it is similar, conjoined, but not exactly the same party, such as a co-insurer? And it's these more difficult scenarios that I wish to address. In many civil law jurisdictions, including, I believe, Greece, the triple identity criteria is applied strictly, and it is the operative part of the award, the dispositive, only that has res judicata effect. So I will focus on where the common law may take a different approach. And I wish to address 6 themes or 6 topics. The first topic is the question of when faced with a legal issue, any lawyer should ask him or herself, what is the applicable law? For issues relating to res judicata, we must ask ourselves whether res judicata is a rule of procedure or substance. I understand that in the civil law, res judicata is generally characterized as procedural and belong to the lex fori, and that would also be the case in international arbitration. In the English common law, Lord Millett, when he was sitting in the House of Lords in 2000, characterized res judicata as substantive. However, it should be said that others see res judicata as being a rule of admissibility of claims, and therefore procedural. But in international arbitration, the debate is about whether it should be the law of the seat of the original award, which law gives original effect to that award, or should it be the law of the seat of the subsequent proceedings, the lex fori of that arbitration, or should it be the law governing the agreement to arbitrate, which incorporates an express, if you referred to procedural rules, or implied agreement, then any award will be final and binding. The International Law Association, to which I referred earlier, recommended a transnational approach for international arbitration with the development of rules suitable for arbitration. But I'll look forward to the view of the panelists as to their particular views on that. So having got over that not easy hurdle, let me turn now to the second topic. Does res judicata apply to the operative part of the award only, the dispositive, or also to its findings or reasoning? I understand that the civil law generally answers that question just the operative part, just the dispositive. However, in some countries, civil law countries, one may look at the essential motivation to help interpret the dispositive. However, as you may know, the English common law extends res judicata to certain findings in the reasoning part of the award. This is argued as issue estoppel. Once an issue of fact or law has been raised and argued and determined, and it is essential to the outcome, a party to that dispute cannot reopen that issue in subsequent proceedings between the same parties. It is stopped from raising it. And indeed, the International Law Association, in its recommendations, endorsed this more expansive approach. My third topic and third question is related to the one I've just mentioned, and that is whether a party can bring a claim arising from the same facts in later proceedings between the same parties. A claim that it could have brought in the prior proceedings, but it did not. Let's take an easy example. A claims against B for damages, but forgets or chooses not to claim interest. Could it do so in later proceedings, in a later arbitration? I understand that several civil law jurisdictions would say, yes, you can. In the common law, the answer is no. This would be considered an abuse of process. It is referred to in that English way as the rule in Henderson and Henderson, being an 1844 case, in which the rule was espoused, and a more recent authority is Johnson and Gorwood in 2000. This is an exercise of the court's inherent power to prevent a misuse of its procedures, even if it is technically permitted under the civil procedure rules of court. But its application is wholly discretionary. And I have seen the rule in Henderson and Henderson applied by international arbitration tribunals governed by common law systems. My fourth topic and fourth question is, does res judicata apply only in subsequent proceedings between the exact same parties? Now, as I said before, I understand the civil law, most civil law or all civil law jurisdictions would usually answer that, yes, the exact same parties. In the English common law, res judicata may extend to privies. A privy is someone or something that is very closely associated. There are three categories: privies in blood. So, for example, an heir may not be able to bring an action separate from the person that bequeathed property or rights to his or her heir. The second category is privies in title. So that applies to persons who succeed to the rights or liabilities. For example, somebody who's managing an insolvency cannot reopen issues that had already been determined by the underlying bankrupt. Or thirdly, privies in interest. And it's this last category, privies in interest, that's the hardest to find. Perhaps a good example would be a trustee who sues on behalf of a beneficiary if for any reason, or vice versa, there has been a determination of an issue between a trustee and another party, then a beneficiary cannot sue separately. The early decision is binding on the beneficiary. But there are other examples. I gave one, for example, of co-insurers, certainly in relation to historic English partnership law. If one partner in a partnership has brought suit, can another partner separately sue? For clarification, companies and its shareholders are not regarded as privies. And one judge said it's a question of justice and common sense. But you might agree with me that that was not especially helpful as a guide. And I should probably say that this is a very interesting issue of sort of academic debate, but doesn't arise particularly often, and certainly less so in the arbitration context because of the contractual nature of arbitration. I don't have time this afternoon to venture into a discussion of res judicata and investor-state arbitration, But I just mentioned that that sort of issue of privies has arisen because of the ability under that scheme for a company and its parent or parents to bring separate BIT proceedings. And the question is whether a parent should be bound in any subsequent BIT proceedings by a determination that has already been made in respect of its subsidiary, and CME and Lauda in Czech Republic is a classic example of that. My fifth topic is this: when does an award lose res judicata effect? Now, in the time I have left, I'm moving slightly away from the strict parameters of my topic, namely subsequent arbitration proceedings, to mention a couple of aspects of res judicata and its interaction with court proceedings. So, when does an award lose res judicata effect? I mentioned earlier that only a court can set aside an award or hear an application to enforce an award which may be refused. I'm sure you're all familiar with the grounds for setting aside awards or for refusing enforcement, and I don't propose to go into those this afternoon, given how familiar they are. But in this context, there may be a tension between, first, on the one hand, a pro-arbitration policy, whereby there is a presumption in favour of the recognition and enforcement of awards, and on the other hand, not giving effect to awards improperly obtained. And one interesting example of this tension is where the losing party argues that the award was procured by some dishonesty. I'm not sure whether you share my experience, but almost every losing party thinks that the successful party was not wholly truthful. And in some awards, you may see that the tribunal prefers the evidence of A over B, implying that B was consciously or unconsciously not telling the truth. But that of itself cannot be the basis for denying res judicata effect. Just to give you the English law position, there's two principal criteria where the court will open up a judgment, and I think the same approach applies to arbitration awards. There has to be conscious and deliberate dishonesty. Conscious and deliberate dishonesty, not just misstatements under cross-examination. Conscious and deliberate dishonesty in relation to the relevant evidence, which must be material or relevant to the judgment or the award. Two very important aspects: conscious and deliberate dishonesty, and second, that evidence, or it could be action, it could be a statement given, or it could be concealment of evidence, must be material, and that the fresh evidence that has come out subsequently must be such that it would have entirely changed the way in which the first court approached and came to its decision. Moving on to my sixth and final topic. Should or do the principles of res judicata apply to the setting aside and enforcement proceedings? And in this, let me mention three scenarios. First, what if a party has successfully set aside the award at its seat? Does that decision have res judicata effect? Well, we know the answer to that is negative. The New York Convention gives a discretion to the enforcement court of another country to ignore the setting aside at its seat. Article 5, 1E. As you know, it usually respects that earlier decision, but there are very notable but rare examples where the enforcement court of another country has not. Second, And the converse of that, should a party that has applied to set an award at the seat and fails be entitled to raise the same grounds to resist enforcement in another country? Now, I believe the orthodox thinking is that the losing party is not prevented from raising the same grounds, be it lack of jurisdiction or anything else. Why is it allowed to do that? I expect it's similar to the reasons, although not expressed in the first scenario, in that the enforcement court is seen as autonomous from the courts of the seat and must come to its own decision. But the third scenario, what if the successful party seeks to enforce the award other than the seat, and the court at that other country makes a ruling in favour or against enforcement? There aren't enough assets, or there's cannot be fully satisfied, and the successful party then seeks to enforce that same award in yet another country. Can the same arguments, either in favour of enforcement if it was refused before, or resisting enforcement if enforcement was allowed before, be made? Let me summarise the English law position. In 2012, a Court of Appeal case between UCOS and Rosneft found that issue estoppel did not operate to prevent the enforcement of an award in England where enforcement had been refused by the Dutch courts. The seat, I think, was originally Russia. And that was because enforcement was being resisted on grounds of public policy, and the court held that whatever the Dutch courts had decided, they had decided as a matter of Dutch public policy, and that did not have res judicata effect in England because England had to decide on the basis of English public policy. The question came up again in another case in 2014 between Diag Human and the Czech Republic. The Austrian courts had decided that the award was not yet binding, so could not be enforced in Austria. Diag then tried to enforce the same award in England, and Mr. Justice Eder applied the usual test to ascertain whether issue estoppel arose and concluded that it did. So you can see there is in England in any event, there's a different approach to as between the seat and the first enforcement court, but res judicata and issue estoppel may, and according to Mr. Justice Eder, will apply as between one enforcement court and a subsequent proceedings in England, outside public policy. And I have sympathy for that approach because that would be the usual application in England of the principles of res judicata. My very final point is this: is a failure by a tribunal to apply res judicata in its award a ground for setting aside? That raises the question of whether res judicata is part of mandatory public policy or not. But I'll leave that thought hanging there and invite our panelists to comment on that rather difficult question. With that, I conclude. Thank you for your attention, and I look forward to learning more about Greek and civil law on res judicata from my fellow panelists. Thank you very much.